I graduated law school in '74, and I was hired by Bronx Legal Services, which had a specialty landlord and tenant office. The office was at 579 Cortlandt Avenue in the Bronx. And I came in, and there were 10 staff attorneys who defended tenants in principally non-payments, but of course holdovers as well. We had a small portion of the office that did New York City Housing Authority cases, but a majority of it was private landlords.
At that time, was the housing part separated from the civil court for these proceedings, or were you still coming in on civil court proceedings?
No.
involving housing?
The housing, I started in the August, September of 1974 for Bronx Legal Services. By that time, the housing court had been in existence for about a year. It came into existence because the civil court was overwhelmed by housing cases. The stories I heard and have been substantiated was each county of the major four had two judges, a civil court judge to do the housing court calendar and one civil court judge to do the housing court trials. The numbers were obviously smaller back then, and what happened is that there was a push to force more trials, and as the push took shape, the two judges were not capable of handling the volume. So there were lobbying and negotiations, and I don't know who the proposal was, but there was a woman judge who became a housing judge, then became a Supreme Court judge, who was in the administration up in Albany, who was very much involved in the language and the putting together of the housing court. And that came into existence. I think the bill passed in '72, but I don't think the court actually opened until '73. I started in '74.
Okay. Well, when you're talking about the push, I have often heard in some of the war stories told that legal services was very instrumental in when representing tenants, appearing and demanding to go to trial, to create this backup in the court so that the resources would be given to
I
the
was
housing
similarly
courts.
told that in the Bronx, where they had 10 attorneys to do L&T matters, their attempt was to force the court system to do something to address the problem, because it was inadequate to have two judges to handle 100 cases a day. All right, so yes, I think they did two things. I think they purposely demanded trials to slow the process down for two reasons. One, it bought their clients more time, and secondarily, to force the courts and or the legislature to understand that they needed more, that what they had was not adequate, and it wasn't serving the needs of the court.
In your experience as an attorney for legal services back in the 70s, were the problems that the tenants had then very similar to the problems you see as a judge on the bench today?
Very similar. In my stay in Bronx County, they are remarkably similar with some exceptions. When I was in Manhattan, they were different because there were different issues in Manhattan. Manhattan landlords wanted to reclaim apartments on non-primary residence cases, owner's use, luxury decontrol. You did not, nor do you see those kinds of cases in Bronx County now. Did you see them back in the 80s with any regularity? I said with any regularity. The biggest differences now, the staffing for the court has dramatically changed. The resources and technology for the court has dramatically changed, and the amounts of rent has dramatically changed. Back in the 70s when I first started, 80s when I got on the bench, it would not be unusual to see rents in the Bronx of $300 or $400 a month. Not at all unusual. Now one is hard pressed to find rents of less than $1,000 a month in the Bronx, all right, which is a substantial difference. The other substantial difference is that I believe that the landlords in the Bronx are taking better care of their buildings now. partially because the rents are much higher and they don't have the defense or excuse of I can't afford it, although we hear that and continually have heard that. But when rents are $1,000 a month, as opposed to the old $200-300 a month, then they have the ability to take better care of their properties. Plus, during the course of my tenure, there have been all sorts of programs to replace boilers, to replace windows, to replace roofs and upgrade. And I think probably the Bronx has certainly utilized its fair share of those programs. I can't speak for Brooklyn or Queens because I have not sat there with any regularity. I sat in Queens a couple of times to fill in. So the biggest differences are the amounts of rents, the technology, and the staff of the court, at least in my mind.
I know certainly in the 70s and early 80s, there were very few separate housing court parts in the system, or especially in the Bronx.
The Bronx, when I started...
How was business done in the Bronx housing?
Oh, the facilities, as I said, have changed dramatically. When I first started, we had a court officer and a judge. And we had a tape machine that was the size of a locker. And every morning the tape machine had to be rolled out, set up to be utilized. It was a reel-to-reel tape machine. You had to put out the microphones. And that was done by the officer. Then the officer checked everybody in. And then the judge conferenced every case, heard arguments on every case, tried every case. And the officer would then make entries into the calendar. And my first courtroom was probably 10 by 15. At most, I had 2 rows of small benches that I could probably sit 12 people. The officer's desk was at the entrance to the court. Then there was the judge's bench. And I was one of the lucky few. My courtroom had a bathroom that was utilized by most of the other judges because there were no other private bathrooms to be found. And the people would check in with the officer, the cases would be conferenced by the judge, allocated, and the people would be sent on their way.
For the most part, during that time, cases were resolved by stipulation.
I would say 90% of the 75% of the cases were resolved by straight stipulations with the right to restore or submit an affidavit for judgment at the end. Most of them provided for, I would guess, 3 weeks to 30 days for the money to be paid. And sometimes if the tenants were forceful enough and or vocal enough, repairs would be included. Most of the times, repairs weren't included. It was just a matter of getting money.
Do you recall a time where a housing court where tenants didn't actually even get out of the main Part 18 and cases were basically resolved on the calendar call in Part 18 without stipulation?
I'm really going to date myself because when I first started, there was no Part 18. There was a Part 17 in the Bronx.
17, okay.
And yes, the Part 17, which was the calendar part, was utilized to assign cases. When the housing court was first established, the housing judges were considered slightly more than referees, and the original, I don't want to say legislation, but the original effect was that the judge sitting in the calendar part assigned that case to the housing judge referee. The question was it to hear and report, or was it for that judge to decide? In the early days, I think it was presumed it was a hear and report, and the civil court judge who had sent it out would pass on everything. That quickly changed when we were given unlimited authority, and we had contempt powers, and we were considered a court of record, and we were to do everything. But for the longest period of time, Part 17 in the Bronx, Part 18 in Manhattan, I don't know what they were called in the other counties, which was the calendar part, would also take stipulations on the record. Sometimes the tenants would actually have a hard copy of what they had agreed to. Sometimes it was just on a stenographic record where it was handwritten on a file. That moved cases along, and the judges who sat in the calendar courts got credit for resolving cases. That happened, but as an attorney, you didn't see it. I mean, as a tenant's attorney, because if I was on the case, I would not allow a stipulation to be on the record. It would be handwritten traditionally by me or by one of the other tenants' attorneys. Landlord attorneys had so much business that they didn't mind, and they even encouraged the tenants' attorneys to write the stipulations, and then they would be most of the time allocated, not necessarily, right, and move on to the next case.
How do you feel the initiative that came in 1998 changed the way the courts work? Do you think it's better?
You don't really think I'm going to answer that, do you? That's a law that was passed, and of course the law is a good thing. What did it change? The biggest change that I saw is that prior to that, judges for the most part held a case from start to finish. The Supreme Court for years had argued that we should have the system where one judge handles the case from its inception till its conclusion. I don't know if they still have that. Not sure. Yeah, individual assignment system. But that's what the housing court always was. With the initiative in 97, 98, they took that away. They set up resolution parts, specialty parts, trial parts. The resolution parts are overwhelmed with work. It seems to me that in many instances the resolution parts should be permitted and or required to take the case from start to finish, because they theoretically have more knowledge about what's happened to those cases than somebody who's worked on it for 7 months and then it gets sent out to trial for somebody who has no experience with the case. I certainly would have advocated, if I had been asked, to allow an IAS system. To defend the bill, it would appear that trials get disposed of more quickly now because you have dedicated judges who will hear or be ready to hear those cases. The fact that they are ready to hear those cases generally means there are less actual trials. The threat of a trial is wonderful, but going to trial, as we are aware, sometimes is difficult. So it often leads to settlements and resolutions that you might not be able to obtain if it stayed in a resolution part. I also believe that if the resolution judges had the tools and power, they could move cases as quickly as the trial judges. There's no real answer for complex trials, though. I mean, complex trials are just difficult no matter where they are.
Now, in the initiative, and even before the initiative, I believe, there was a specialized part for HP proceedings.
There's always been
where a tenant brings a landlord to court for repairs, or HPD brings an enforcement action, heat and hot water, 7A, and other types of proceedings.
They have always existed from the time I first got into the court in 1974 until today.
Now, I know you have sat in that particular part for many years, both in Manhattan and in the Bronx.
I have shifted in and out of that part as is required, and have, yes, presided in the HP part for, when I was in the Bronx, I sat in the HP part for, I think, almost my entire tenure in the Bronx. My first go-around. Then I was in Manhattan, and probably half to two-thirds of the time I was in Manhattan, I also presided in the HP part. And I've been in and out of the HP part in the Bronx.
Now, many of the people that are involved in our committee are under the belief that the housing court was created more because we need to enforce code violations as opposed to the other issues that ultimately seem to get litigated in housing court.
Yes.
How effective do you feel the HP part on its own has been with respect to the obligation to preserve the housing stock in the city?
I think it's sort of a misplaced question. I think part of the selling point of the Section 110 of the Civil Court Act, which is the enabling section for our court, was many, many paragraphs talked about enforcing code requirements, maintaining and improving the housing stock, and that was part of the argument for setting up the court. anyone that knows would realize that in the Bronx there are 15 judges. There is one housing part. In Manhattan, I think there are now 12 judges, one HP or housing part where actions can be commenced. Similarly, in Brooklyn, one part dedicated to it, none in Staten Island, and I believe Queens has a housing part or an HPD part that is part-time. I think it's 3 days a week. So even though the legislation talked about how important that role of the court would be, I don't believe it's ever come to fruition because of staffing, because of the needs of the other aspects of the court, and there's no question that the largest portion of our cases, whether it's in Manhattan, Brooklyn, Queens, Staten Island, is the non-payment of rent. And I don't have statistics, I'm sure somebody does, but my belief would be between 80 to 85% of the court's work is non-payment proceedings. Perhaps 10% would be holdover proceedings, and another 10% would be the HP proceedings, whether they be tenant actions or actions commenced by HPD. So although in the enabling legislation, and one of the selling points would be how much better it would be to maintain the housing and to enforce the law, I'm not sure that that aspect of the law was ever accomplished.
Okay. Over the years that you've been sitting in HP parts in various counties, how do you see the role of HPD in dealing with these proceedings?
Shrinking.
Okay.
Shrinking. HPD, when in the height of what I would call the housing crunch and crisis, which would have been the late 80s through the 90s, the Manhattan HPD litigation office had anywhere between 12 and 20 attorneys litigating heat and hot water cases, as you said, comprehensive actions forcing landlords to make repairs, civil penalty actions seeking penalties when they fail to make repairs, special programs for lead paint, for window guards, at one point there was a big push for mold cases. And again, HPD staff, the litigation staff, I would suspect had between 50 and 60 attorneys.
And do you think that is due to budgetary constraints, or do you think that there's been, and again, it's speculation, how would you know, just a change in the policy?
I think it's a combination of everything. There was a major change in the city's policy. The city now seems to be as interested in entrepreneurial programs where they move buildings away from city control, take them away from landlords that they perceive to be poor landlords, and give them to some entrepreneur, not give them, negotiate a deal with entrepreneurs to take them over. I imagine it's been somewhat successful. I'm not 100% sure. The city used to manage thousands, if not hundreds of thousands of units in property that was taken in foreclosure of tax liens. They are, I believe, totally out of that business. When they take a building, they immediately sell it and let new managers run them, so that function of HPD has dropped dramatically. I think, and again, it's a personal opinion, that the enforcement aspect of HPD has been greatly reduced. Staffing is some of the issues. I also think that property, as I said before, when rents go up to $1,000, $1,200 a month for apartments, landlords can and do take better care of them. Growing up in this business in the 70s and 80s, there were a lot of rundown properties that there was not enough money to do anything. And I don't know what happened to them. I don't know if they've been rehabbed or they've been destroyed, but some of those are out of the picture. So I think it's a combination of administration's redirection of funds. I think it's a combination of a question as to whether or not the court by administration is the best vehicle to use to enforce the housing standards, notwithstanding the law that says that's what you're supposed to do. So there has been a change. The volume of cases I think is dramatically down, partially because many of the properties have gotten better, and HPD's staffing and funding has been dramatically reduced for enforcement purposes. How much money they have for projects and for rehabilitation, I don't know. They may have more and use more for that, but I'm not aware of it.
Do you think the housing court is certainly, I'm sure I know the answer to this question, is better than it was 40 years ago?
40 years ago? It's different. I can't say, is it better? It's somewhat interesting that notwithstanding the technological differences, the staffing differences, and some of the facility differences. Again, my courtroom, if we could sit 12 people in it, it was a lot. Now I have a courtroom you can put 20 people in. It's got an elevator to get people into the witness box. It doesn't work, but we have an elevator to get people into the witness box. Our recording method, as opposed to the old reel-to-reel tape recorders, is now computerly digitized so that it's almost invisible to the people that are there. So that all of that's an improvement. However, in the Bronx, the numbers keep growing. The number of people that come to the court keeps growing, and it's in many instances it's not a legal problem; it's a social problem. When people don't have money, where do they go for money? When the government is the one that's funding their housing, and the government's not so quick to give up their money, it's difficult to get that money. As the rents go up, the government's giving more and more. And it becomes more and more difficult to get larger sums of money. I also see less of a focus on the repairs. In most of the resolution parts in the Bronx, the focus is on how do we get the money. We'll take care of the repairs, and many times landlords do. Sometimes they don't. But how do we get the money? And it's not uncommon in the Bronx to see tenants of those $6,000, $7,000, $8,000, $10,000, and the government is not so quick to give away or to pay $7,000, $8,000, $9,000, $10,000. So with all of our advances, I think the shortcoming is in at least the Bronx, the administrative connection between landlords and the people that pay the rent. The court has become one of the vehicles for that. And I'm not sure that that's appropriate. But we don't have a choice. There's nobody else out there doing it, so that a lot of our energy is used to get government agencies to approve and eventually pay the money.
Well, over the years, there have been various programs instituted in housing court. There's information tables for landlords and tenants. There was a public assistance office opened up in the courthouse. There were in the
liaisons in the courthouse.
Have, legal services, legal aid, the non-for-profit assisting tenants. We have forms on how to represent yourself for trial. We have resource lists.
We have computers so you can self-represent. We have all of that.
Do you think all of this, in fact, is assisting tenants? Do you think it is still working on the word of mouth, what's going on, and the judges, or even attorneys representing landlords pointing people in the right direction to try to get assistance?
I think it's all of those. I think that landlords' attorneys send people to the appropriate agencies because they want their clients to get their money. I think that it's the court staff that is diligent in trying to get people directed to the right place. I think all of the programs you've mentioned, at least in the Bronx, where we have legal services, we have senior projects, we have legal aid, we have HRA, we have other facilities, other providers that have space in the Bronx. All of those go to solving the problem of the payment of rent. All right? We do not have a window that's staffed by HPD to talk about conditions, to talk about what you're entitled to. We have never had an in-house facility where tenants can get advice on what to do about the repairs, which was, when the court was first established, one of the selling points to the legislature about why we need this court. So that's been a shortcoming. All right. In terms of all of the projects, it's a never-ending debate. It's a never-ending problem that the court believes that if the governmental agencies that were responsible for making the payments of rent would do it without having to come to court, they might put us out of business. Not likely, but it would save landlords money, it would save the government money, it would hurt landlords' attorneys, it might hurt the court in that we wouldn't have as much business, but the reality is that if it's only about the rent, there shouldn't be a need to come to court in most instances. And what I've seen and what every judge that's sit in this court seen is that over the years, it's more and more coming to court to get your money, not less and less.
What, if any, changes would you like to see made in the court?
I think we need more interpreters. We have in this wonderful city of ours more and more diversity, and you talk about slowing the process down. We cannot proceed without an appropriate interpreter, and in certainly the last year to two, it seems to have gotten worse and worse and worse. It also seems that the administrative agencies that are responsible for paying the rent have slowed down, whether it's because of the economy, whether it's because of the resistance to providing those services. I don't know. So what I would like to see is a greater connection with outside community agencies, outside the court, and the agencies that are paying the rent. The question of working families who pay the rent is a separate one. And again, in the Bronx, my experience is you don't see nearly as many working families who are missing their rent payments as you do those who are receiving benefits. And interestingly enough, some of the working families, the landlords are more tolerant of in terms of they may not give them a full rent increase because it might hurt them. Where if you're receiving government benefits, it never ceased to amaze me that the amount of the rent was almost always plugged into the maximum amount that the government would pay. So I think you need a better coordination outside the court with rental providers. I think you need, if you want the court to work as it appears to have been legislated for, you need more involvement, not less involvement, from enforcement agencies like HPD. And there's very, very little of that, ever has been. I've never worked in a county that's had more than one part. No, I stand corrected. When I first was in the Bronx, and I was the HP part, during the winter, a second judge would be assigned to help with heat and hot water cases. So that during crunch time in the Bronx, when things were really bad, there was a second judge. That's the only experience I've had with a second judge in the HP parts, which seems to be contrary to the enabling legislation, which talked about how wonderful this was going to be for code enforcement and maintenance of housing.
I know when we interviewed Judge Gould a few months ago, and he talked very much about how when the housing court was created, it was this real goal was to improve the housing stock. And when we talked a little more to him about his experience as a judge, he said that there were so many factors to consider that it just wasn't about repairs, that, you know, landlords needed to collect rents in order to make repairs, in order to maintain their buildings. And he actually admitted that, you know, that it could not really be the primary purpose of the court, that there had to be balance between trying to preserve the housing stock and trying to keep landlords in place in buildings.
I don't disagree with Judge Gould. Judge Gould walked an interesting tightrope since he had worked for the administrative agencies, and during his tenure there, he advocated for more and more administrative enforcement, and then he came onto the bench and now had a responsibility of doing court enforcement. I'm not sure where his loyalties really resided. He's right. I mean, when you're a judge, you have to take into consideration everybody's positions. And there are landlords who get hurt when people don't pay their rent. And there are landlords who get hurt when taxes keep going up and up and up and up. But in the same instance, I've been to many of these buildings, and I guess one of the measures is, would I want to live there? But a better measure would be, could I live there? And the sad fact is that in a large percentage of the buildings that I've inspected, I wouldn't want to live there. I'm not sure I could live there. And I think the goal would be to make it so that every house is a place that people would want to live, as opposed to a default living situation. That's a wonderful world, but it's not the world we all live in. Nor do I see the housing court being able to dramatically change that. I'm not sure what would change that. So we function from day to day, and most of the judges do the best they can.
I've been at a number of meetings where there's conversations about turning housing court into an electronic filing court. Could you see that happening?
Absolutely. I think in this day and age, with the technology we have, anything electronic is possible. To the extent that it happens, do I think it will make things better or worse? I look at the population that comes into our court. Right, and when you talk about a population that, as I said earlier, we need more and more interpreters because we have such a diversity, I'm not sure how electronic filing will help. I don't know the percentage of litigants that have access outside of court to the technology, the computer systems that the electronic filing would allow. And in all of your questions, you've not brushed upon what might be the most telling, which is what percentage of the litigants are represented by counsel. When you talk about electronic filing, Supreme Court, you talk about electronic filing in most of the other courts, 95% of the people are represented on both sides. When you talk about the housing court, 95 to 98% of tenants, at least in the Bronx, are not represented, unrepresented, and therefore the electronic filing, if it becomes mandatory, how does a tenant electronically file a motion? How do they make the motion, but how do they electronically file it? So do I think we will eventually get there? I think the way technology is, the society is driven by technology. I think we will get there. How it will be implemented, given the large number of pro se litigants, is a difficult question to answer. The reality is that electronic filing in our court will certainly benefit landlords and landlords' attorneys who won't have to physically come as often. I don't think it's going to make a substantial difference to the tenants' lives, in that they're still going to have to come to court because they don't have access to forms, they don't have access to papers, they don't have access to computers, they don't have knowledge of those computers, and in many instances, electronic filing, now you're going to need somebody from the court to translate. I mean, if a landlord serves a dispossess, one would like to think that a tenant who can't read it would find somebody to help them. But an electronic filing's sort of different. You can print it, and then it becomes but I think it's destined, as I think every court is destined, to become more technologically advanced. So yes, I think it's on its way.
Do you think it would be helpful if the courts created a system where stipulations that are being allocated are in fact scanned, so that a judge coming afterwards reading an order to show cause would be able to get access to what has gone on in the past?
Technically, all stipulations are in the file.
But
so,
files are often
one
not
second.
available.
So if you have access to the file, you should have access to the stipulations. You've just made an argument for electronic filing.
Well,
Right?
not filing,
But that's a filing.
Record keeping by the court as opposed to a pro se.
That's what electronic filing is that every document that would become a part of the court record will now be maintained in a computer. One argument is that it saves paper. The other is that you don't lose the documents. The interesting question, of course, is after the horrible or sensational storm Sandy, the courthouse computers have been running at half speed. Right? So now you talk about if everything's going to be scanned and we have computer glitches, what happens to the ability to review? What happens to the ability to get access to that material? And again, I'm not a technological genius, But I try to get information from the HPD computer, from the court computer, and in the last month, it's been taking substantially longer. That's without, I think the Bronx has about 90,000 filings a year. So if all of that's going to be scanned and computer accessible, that, at least from what I understand, will slow things down in the retrieval process. So I think it's inevitable. I think that it's a good thing to have access to whatever's in the file. I might argue that electronic filing is not appropriate, but every time a document goes into the file, it could then be scanned. But again, that's staffing. When you have a stipulation and the court has 90 cases a day, and let's assume you have 75 stipulations. So some of those turn into judgments. All of them have to be entered into the computer as to what the disposition is. And now if you want a copy of every stipulation, they all have to be scanned, all right? And that's staffing, which we are having difficulties with because of budgets.
Is there anything else that you would like to speak about?
No, I'm content. As most people know, I still, and some people think I'm crazy for it, I used to say, like my job. I still love my job. There have been good days and bad days, and some days you're exhausted, and you go, why am I doing this? And then most of the days, you've provided a service, and you have helped, on a really good day, helped hundreds of people. Like on a not such a good day, a few people. And that's what keeps me going. I still, and people, again, sometimes look at me like, what's wrong with you? I still like going to work. I mean, there are problems, and it's not always fun, and it's not always enjoyable, and there are often headaches. But in the scheme of things, it's still a place that I like to go, and I feel almost every day a sense of accomplishment.